The morning I found the envelope, the kitchen smelled like burnt coffee and old wood. I had left the pot on too long again. That had been happening more often since I retired, small things slipping through, the kind of thing my wife used to catch before I even noticed. She had been gone 4 years by then, and the house still hadn't learned to run without her. I was 63 years old. I had spent 31 of those years working as a land surveyor for the provincial government in British Columbia, most of that time out of the Kamloops office. I knew property lines the way some men know hockey statistics. I knew where one man's land ended and another's began. I thought I understood ownership. I thought I understood what belonged to whom. The envelope was sitting under a rubber band with the weekly flyers, plain white, no return address. My name written by hand in blue ink, careful letters, the kind a person writes when they want to be read clearly. I stood at the counter and opened it. Inside was a single sheet of paper, a name I recognized, a date, and 4 words typed at the bottom. You need to know. My brother-in-law's name was Gerald Foss. He had married my sister, Paulette, in 1987, at a small ceremony in Kelowna. I had been best man. I remembered standing at the front of that church, thinking Gerald seemed like a decent enough man, quiet, careful with money, the kind of person who reads the fine print on everything. He worked in commercial real estate. Later he moved into property management. By the time Paulette died, in 2019, Gerald had built up a portfolio that no one in the family had fully understood the size of. Paulette died of a stroke. She was 58. It was fast, the way those things sometimes are there one morning, gone by afternoon. She had no children. Gerald had no children from a previous relationship. The two of them had lived in that big house in West Kelowna, the one with the view of Okanagan Lake, and when she died, Gerald became the sole owner of everything they had built together. That was the understanding. That was what I had believed for 5 years. The paper in the envelope was a photocopy of a document. I read it 3 times before I poured out the burnt coffee and made a fresh pot. Then I read it again. It was a property transfer record, dated 11 days after my sister's death. A parcel of land, agricultural, 42 acres, sitting near the edge of the property my parents had originally owned outside of Vernon, transferred out of a joint holding into Gerald's name alone. The holding had been established in 1994. The joint parties listed were Gerald Foss and Paulette Foss, née Drummond. My sister's maiden name was Paulette Drummond. My name was Ronald Drummond. And the 42 acres that had just been transferred quietly into my brother-in-law's name had originally come from my parents' estate land that my father had specifically said, in conversations I remembered clearly, was meant to be divided between Paulette and me when the time came. My father's name was Douglas Drummond. He had passed in 2011, my mother, Carol, in 2016. They had lived on that land outside Vernon for 40 years. My father ran a small orchard. My mother kept the books. Neither of them left behind much in the way of formal paperwork. They were practical people, not legal people. My father had a will, but it was handwritten, and when it was probated there were questions about certain parcels that had already been transferred into Paulette and Gerald's joint name for tax purposes years earlier. At the time I hadn't thought much about it. Paulette was my sister. I trusted her the way you trust family, not because you verified anything, but because the idea of verifying feels like an insult. She told me the land arrangement was temporary. She told me we would sort it out properly once they had refinanced some things. She told me there was no rush. She died before we sorted anything out. And then Gerald, 11 days after the funeral, transferred the land into his name alone. I drove to Vernon that same week. Not to confront anyone, not yet. I needed to see the land first. I needed to stand on it. It was late October. The orchard had been leased to a fruit operation for the past several years. The trees still stood in their rows, the leaves turning, the ground underneath soft from a recent rain. I parked on the side of the road and walked the fence line the way my father used to on Sunday afternoons, hands in his pockets, not saying much, just looking. My father had planted some of those trees himself. I stood there for a long time. The air smelled like wet soil and wood smoke from somewhere nearby. The lake was visible in the distance, flat and gray under the October sky. I was 63 years old, standing on land that should have been half mine, and I felt something settle in my chest that wasn't grief exactly. It was older than grief. It was the specific weight of realizing that someone you trusted had been quietly, carefully, making decisions that cost you something you didn't even know you were losing. When I got back to Kamloops, I called a lawyer. Not a friend, Not someone I knew socially, a proper estate lawyer, recommended by a colleague who had dealt with a property dispute of her own some years back. Her name was not important to this story except to say she was thorough and she did not waste words. I brought everything I had: the photocopy from the envelope, my father's original will, the probate records I requested from the courthouse, old letters from my sister, a handwritten note from my father, dated 2008, in which he described the 42 acres as belonging equally to his two children, regardless of how the transfer had been structured for tax reasons. My lawyer read through everything over the course of 2 appointments. On the 3rd appointment, she looked at me across her desk and said, "The handwritten note is not legally binding on its own, but it establishes intent. And the transfer that happened 11 days after your sister's death, the timing is worth examining." I asked her what that meant. She said it meant Gerald had moved very quickly, and that in estate law, speed sometimes tells a story. I want to be honest about something. During the months that followed, there were moments when I asked myself whether I was being fair. Gerald had lost his wife. He was grieving too, in his way. The land had been in his name jointly for years. There was an argument, I heard it from Gerald himself. Later, that he had simply been protecting an asset during a vulnerable period. I sat with that. I gave it real consideration, but then I went back to the dates. I went back to my father's note. I went back to the conversations I had with my sister over the years, the ones where she said, "We'll sort it out, Ronnie. Don't worry about it." And I thought about the fact that Gerald had never once, in 5 years, mentioned the land to me. Not once. Not at the funeral, not at Christmas, not when he called to wish me a happy birthday in 2021. The way he occasionally did brief calls, 5 minutes, nothing of substance. He had transferred 42 acres of Drummond family land into his sole name, and then continued having 5-minute birthday calls with me as though nothing had happened. That told me something. The investigation, and I use that word loosely, it was more like archaeology, took 14 months. My lawyer filed a request for full disclosure of the estate records. Gerald hired his own counsel. There were letters back and forth, requests that were delayed, documents that arrived incomplete. In the spring of the following year, my lawyer called me on a Tuesday afternoon. I was in the backyard trying to fix a gate latch that had been sticking since the previous fall. I remember setting down the screwdriver and sitting on the back step. She told me that in reviewing the full estate documentation, her team had found something. A second transfer, done in 2018, the year before Paulette died. A portion of the agricultural land, 12 acres, separate from the 42, had been moved into a numbered company registered in Gerald's name. A company that had existed for 2 years before the transfer and had no other apparent assets. Paulette's name was not on the company. Her signature was on the transfer authorization. My lawyer paused and said, "We need to talk about whether your sister understood what she was signing." I didn't say anything for a moment. Then I said, "She was already sick in 2018. My sister had been diagnosed with early-stage vascular dementia in the summer of 2017. We hadn't spoken about it openly. Paulette had been private about it, and Gerald had been the one managing her medical appointments and her affairs in the last 2 years of her life. I had visited when I could. I had noticed she seemed slower, more easily confused. I had attributed it to stress and grief over my mother's death the year before. I had not known, until that phone call, that she had signed a property transfer in 2018. I want to stop here for a moment, because this is the part of the story that I have had to sit with the longest. I don't know, and I will likely never know with certainty, whether Gerald took deliberate advantage of my sister's condition. That is the honest answer. What I know is the timeline. What I know is that a woman with a diagnosed cognitive impairment signed a document transferring land to a company her husband controlled, and that her husband never mentioned this to any member of her family. What I know is that when I finally sat across from Gerald, in a meeting room in Kelowna, my lawyer present, his lawyer present, the kind of room with a long table, and bad lighting, and coffee in a paper cup, Gerald said that Paulette had understood everything she signed. He said she had been fully capable. He said she had wanted him to be protected. He said it the way a man says something he has rehearsed. I watched his face while he said it. My brother-in-law. The man I had stood next to at an altar in 1987. The man who had held my sister's hand at my mother's funeral. The man who called me on my birthday and asked how the fishing was up near Kamloops. He said it, and then he looked down at the table. The legal process resulted in a mediated settlement. I am not going to detail every number, because some of it remains confidential, and because, honestly, the numbers were never really the point. What was settled was this. The 42 acres were recognized as a contested asset, and a portion of the value was transferred to me in lieu of the land itself, which Gerald had since incorporated into a larger property deal. The 12 acres in the numbered company were a harder matter. There was not enough evidence to prove incapacity at the time of signing. Gerald's counsel had medical records, selective ones, that showed Paulette had attended appointments and answered questions coherently in the months around the transfer. I did not win everything. I want to be clear about that because I think it matters. This is not a story about a perfect resolution. It is a story about what happens when you stop looking away. Somewhere in the middle of all this, I received a second letter. Same plain white envelope, same careful handwriting. This time, inside, there was a photocopy of a text message exchange printed out, the names visible. One of the names was Gerald's. The other was a woman I did not recognize. The messages were dated March 2018. In them, Gerald described the numbered company. He described the transfer. He described Paulette as not really following everything these days, and said he needed to move before things got more complicated. I sat at my kitchen table with that piece of paper for a long time. I still don't know who sent me those envelopes. I have my suspicions there was a woman who had worked as Gerald's property manager for several years, who had left his employment in 2020 under circumstances I was never told about. I reached out to her once, carefully, and she didn't confirm anything, but she didn't deny anything either. She just said she hoped things worked out. I thanked her, and we left it at that. Some people know what the right thing is, and do it in the only way they're able to. I am 64 now, 65 in February. I spend a fair amount of time thinking about what the last 3 years of my life have taught me. I think about my sister. I think about who she was before 2017. Sharp, funny, the kind of woman who could spot a bad deal from a distance and say so without apology. I think about what it must have been like in those last 2 years, the world going soft at the edges, trusting the person beside her to hold things steady. I think about trust, and what it costs when it's misplaced. My father used to say that land remembers who cared for it. He said it the way older farming people sometimes say things, as though the ground has something like a conscience. I used to think it was just something he said to make the work feel meaningful. I understand it differently now. He meant that what a person does with what they inherit, what they protect, what they pass on, what they quietly take for themselves says something that outlasts them. Gerald will have to live inside what he did. I have come to believe that is its own kind of accounting. I have a few things I want to say, especially to those of you who might be in a situation that resembles any part of what I've described. If someone you trust is managing an elderly or unwell family member's affairs, pay attention, not with suspicion, with care. There is a difference. Ask questions. Read documents before they are signed. A person with a cognitive condition can seem present and responsive in ways that do not reflect their full understanding. That gap is where harm can happen. Document the conversations that matter. I know it feels formal. I know it can feel like distrust dressed up as practicality. But my father's handwritten note, even though it wasn't legally binding on its own, gave my lawyer something to work with. It established intent. In estate disputes, intent matters. Get independent legal advice before any family property changes hands, even when the family member asking you to sign seems like someone you would never need to protect yourself from. Especially then. A notary or lawyer who represents only you, with no connection to the other party, costs a few $100s and can save you years of grief. And if you find yourself on the other side of this, if you are the person managing assets that belong, in spirit if not on paper, to someone else, I would ask you to sit quietly for a moment and consider what you are actually doing. Consider what it means to look someone in the eye at Christmas. Consider what kind of person you are choosing to be when no one is watching. Because someone is usually watching. Someone usually knows. The orchard is still there, outside of Vernon. I drove past it again last September. The lease operation has kept it up well enough. The trees were heavy with fruit, the rows straight, the way my father liked them. I didn't stop this time. I just slowed down and looked through the window as I passed. My father planted some of those trees. My sister grew up running between those rows. I spent summers there as a boy, coming home in the evenings with stained hands and tired legs, my mother calling us in for supper from the back door. All of it happened on that land. All of it is still there, in some way that I can't explain but believe to be true. I drove back toward Kamloops as the light was going. The highway curves up through the hills, and for a stretch you can see a long way in both directions, behind you and ahead. I'm at an age now where I think about that kind of thing. How much is behind? How much might still be ahead? I'm not done yet. I'm not done asking questions, or standing on land that matters, or saying out loud what I think is true. That, I've decided, is enough.